Hey guys, Sean Bougie, surplusfundsriches.net. You know, a lot of you guys are avoiding using attorneys. I get it. They cost money. Usually they don't know who you are at first, so they're going to charge you money up front as a retainer. You're scared to use an attorney. I get it. But trust me, it's worth it. Let me tell you why. Number one reason, there are states that require a motion. And guess what? You're not working those states. They require a motion by an attorney. And you're not working those states because they require a motion for an attorney. How many people are working those and using attorneys? Probably a whole lot less, right? So there's a whole lot less competition. So you're avoiding states where there's the least amount of competition, all right? Second part is, attorneys have saved my behind on multiple occasions. I would have to guess, given that we've been doing this over 15 years, we've had at least 60 retrievals where having an attorney either made us more money, considerably more money, than their own cost by quite a while, or quite a bit, or made us money where we would not have made money without them. Now, there's other reasons why we use attorneys. We like the attorney getting it out in the claimant's name and using their trust account to break the money out. It's clean and it's legal and it's easy, and you don't have to figure out who the check is or who it's made out to, any of that. It's made out to the claimant, goes to the attorney, they use the trust account to cash it. Easy peasy, all right? Let me give you two examples real quick. One, a lot of you guys don't realize, and this was in a state where a clerk made the determination of the disbursement of the surplus funds. In this particular state, you need to understand something. The clerk handles it in this particular state. You need to understand something, guys. Clerks typically are elected in counties. Why is that important? Because they don't have to have any legal background. In this particular case, this was an ex-state trooper that was a clerk of the court. You think he knew the law? He knew how fast people could drive their car. He knew whether or not they could go over the double yellow. Did he know anything about surplus funds and the disbursement of surplus funds? No. So when we get there, there's a counterclaim to the surplus funds. There's a counterclaim to the surplus funds by a daughter that says that the dad promised her the house when he passed, and even though he hasn't passed, she considered it her property. And when it went to foreclosure as a result and made surplus funds, she should be entitled to the money. The clerk said, "You're right," and granted it to her. Now, I know that sounds wacky, but you guys need to understand something. There's the law, and there's the idiot in between the law and the application of the law. Not always an idiot, but there can be an idiot there. In this case, there was an idiot there. Okay? This guy knew, or thought he knew, how to disperse surplus, and thought, frankly, that there was no law surrounding it. I just feel bad for this girl. She can have the money. Now, our attorney immediately filed to stop that disbursement, and we got the money out. I'd call that a win. Second example, and this is a big deal. This was in a state, this particular state gives a time limit on how long creditors, if there was an additional creditor, a second mortgage, a lien holder, a judgment holder against that owner of the property or the property itself at the time of the sale, they give them 120 days to make a claim. If they don't make a claim in that time period, they're not allowed to make a claim. All the money's due to the ex-owner. That is a beautiful law, and frankly, that should be enforced everywhere. As a result of that, we had a deal where we called him and the guy said, "Hey, I already signed with another company, but they say that this bank is making a claim against the money. It was a second mortgage. They're making a claim against the money, and so we can't have it, so don't waste your time." And I said, whoa, because I had the file in front of me. I said, do you know when they filed? Because the file had been there a while. We hadn't rechecked the case history. So we looked, and it was a bank that was making a claim, and they were outside of the 120 days. They didn't start make the claim until day like 121. Yes, they were going to the court to make their claim the following week, but because the people we were working against had been trying to make a claim without an attorney, they didn't realize the law, the full extent of the law, or they didn't feel like they could make it work because they figured this bank was going to crush them in court. And they were probably right because they didn't have legal representation. So we made the deal with the person immediately, called our attorney immediately, and our attorney was able to show up at the hearing and bat down the bank's claim. Now, guys, because the owner was absolutely convinced he wasn't going to make a dime and was like, yeah, okay, you guys are that cool that you can actually, you're that good that you can actually make money, where these other guys said, okay, fine. And I was able to get a very good split on that. I mean, extremely good split on that, because I was taking a little bit of a risk, and they were, as far as they were concerned, they weren't going to make any money anyway. The total amount we pulled out was over $60,000. Not a bad hit, okay? All I'm going to tell you is we made a fantastic amount of money on that. Why? Because we got paid for knowledge, and we got paid for having an attorney. Everyone else bailed on that deal. The other company bailed on it. They figured it was over. They didn't know what they were doing. They didn't have an attorney to back them up. If you are working surplus funds without an attorney, you're acting like an idiot. Thanks, guys.